Tia and say can say EOCO NDC, one of them social media communication handler. I find AI Gani worthy. AI Gani worthy. Was it not true? Me more update now. Was it not true? Financial Intelligence Center FIC builds new cases against Wontumi. So from EOCO, his sleeping place will change to that of FIC. Now just a chama Wontumi was what is allegation and as a what is I say financial intelligence for our building new cases. A child to me to say Wontumi you better transport on to what financial intelligence what sells for further interrogation. That is Wontumi. Na Wontumi angasa no and say mo and no client in a financial intelligence center if easy Wontumi account on the hotel. Into the script now to young tell latest update. Kino Ofori-Atta so in Semono Banya Michelle. Stay tuned. Young
that EOCO has not allowed him his freedom despite his counsel meeting bail. This excuse of a case file seeking to have the High Court vary the bail terms being used as a basis to continue to keep him.
So in actual fact, the continuous incarceration of Bernard Bosjaku is not out of the ordinary. I mean, if a person has been arrested and is being investigated for the commission of an offense and administered to bail by the investigative authorities, he secures his freedom if he is able to meet the bail bond. If he is unable to meet the bail bond, I mean, he continues to be in detention. The 48-day rule of the Constitution would have been met if the investigative authorities post a bail on him, and then he is unable to meet the bail. So yes, like Pierre Kobe herself, I followed his interventions in this matter, and I think it's perfectly right that they were looking for the sureties to post the sureties for the bail, to stand surety for Wontumi, and until last week Friday, they were almost about getting the sureties to stand for Wontumi until another matter emerged from the court where another lawyer, whether instructed by Wontumi or not, we are not yet clear on that, went to court and sought the permission of the court, the jurisdiction of the court, to vary the bail terms that was imposed on Wontumi by the Office of the Economic and Organized Crime Office.
Counsel, Counsel, that's where the argument comes in, that if he met the bail conditions Friday night, then really he shouldn't have been kept in custody still, despite this application, which we're learning now has been withdrawn, was filed seeking to have the bail terms varied. 50 million was what EOCO had said. They met it. If someone went to court seeking to have it varied, he should have been let go. They say his rights have been infringed upon by EOCO.
Well, your line is not that clear, but are you saying that the imposition of the 15 million and two sureties to justify?
Not the imposition, but the argument being made is that Mr. Wontumi's rights have been infringed upon because, as at Friday night, his lawyer said they had found the sureties, but they could not proceed because of that legal action that had been taken seeking to vary the bail terms. There are those who make the argument that once they had met the 50 million bail conditions, EOCO should have let him go pending whatever determination will be arrived at by the High Court.
That is not what I heard Andy Pierre Kobe, lawyer for Wontumi, say. Now, when a bail bond is posted on a person, and that person provides meets the conditions of the bail, investigative authorities, especially where the bail conditions require that the bail be supported or the sureties be supported by property, will have to go and ascertain the existence of that property, and will have to go to the Lands Commission to ensure that that property has been properly registered with the Lands Commission. That will require time. Until that is done, they cannot let that person go on the basis of the surety and justification provided. And so, yes, I think that it's consistent with practice that when the lawyer said, yes, the investigative authorities were now looking into the possibility of admitting him to bail and verifying the bond posted until the matters came in. He was perfectly right. He was perfectly right. I sympathize with him for the reversal of the progress that he had made to secure the release of his client.
Counsel, yes, as always.
Nobody violated the rights of Wontumi.
Right.
Nobody. Because, I mean, he was granted bail. He simply was not able to meet the bail bond until later in the day on Friday. Whoever went to court to vary the bail terms, we don't know who instructed that person. That person might be a busybody or not, but we don't know who instructed that person. And because of the pendency of the application to vary the bail bond, which can affect the bail posted on Wontumi, it will be reasonable to await the execution of the bail bond until the court pronounces otherwise.
Counsel, as always, appreciate you speaking to us. I'm sure we can pick up the arguments and the conversations on the matters of law a lot later, but I appreciate you speaking to us. That's private legal practitioner Newz Fusheni. He's also a former minister for lands and natural resources. We're staying on the subject of Wontumi because private legal practitioner Martin Pebu says EOCO has not managed the process of the arrest of Chairman Wontumi well. He told TV3's Key Points that EOCO should have brought the public the charges and facts of the matter against Chairman Wontumi on time.
You see, one thing that EOCO too must learn from, you see, all these charges of unreasonableness, etc., it's also showing that EOCO hasn't managed the process well. Let's be very, fair.
How so?
Yes, they should have come out with the facts by now. And Mr. Atta is a journalist, okay? Maybe from here we'll be prompting him.
Raymond Atta.
Yes, yes. He's a journalist. You know information flow. If you are taking somebody like Wontumi, he has a lot of following. So put out those allegations, yes. Look, there's no rule that says
but there are those who have argued that EOCO does not owe us a public statement.
No, that is absolutely
on what they are
wrong.
doing.
That's anybody who says so is absolutely wrong. Governance runs on information. You can't say that it's not anybody's private property. Then you don't even know what you're about. So
well, as an intelligence...
No, intelligence agencies give information. It depends. You manage it. You see, what was brought out later by Dr. Sremsai, yes, but it was late. You see, and especially as Mr. Acha is a journalist, so you should have known that our society thrives on information, free flow. So bring out, if you had to say that he's involved in tax fraud involving 1 billion Ghana cedis, that doesn't change anything. Well, the fact that has been put out there change the investigations. It's your sources and how you are gathering the evidence that you don't put out. But if the allegation is that somebody's brought you a petition that is involved in tax fraud, 1 billion Ghana cedis, I hear on the grapevine to things like he has bought a lot of stolen vehicles.
That's Martin Pebu, who is a private legal practitioner. Let's move away from that. I mentioned special prosecutor because he's our next subject matter. He says that, or is calling for a radical reimagination of the fight against corruption. At the West Africa Regional Anti-Corruption Dialogue, Kesi Jabin urged stakeholders to move away from abstract frameworks and instead anchor anti-corruption efforts in practical, functionally specific strategies. He's also advocating for the creation of a dedicated chapter on anti-corruption to strengthen the regional response.
Mr. Chairman, corruption is debated. Corruption is stifling us. We cannot enhance access to...
How far have we come since that first declaration of Mr. Ken Ofori-Atta as a wanted person and a fugitive from justice? Let's try and refresh your memory at home and then look forward to that much anticipated news conference expected a lot later today by the special prosecutor. And so here's a list of the 5 cases to which Mr. Ken Ofori-Atta, the former finance minister, has been labeled as a prime suspect in. The first, the Petroleum and Minerals Revenue Assurances agreement between the government of Ghana and also the Electricity Company of Ghana contract termination between BXG. Then there's the National Cathedral Project, that we know has become what many have described as a very expensive hole in somewhere in the capital of the country. Then there's the ambulance purchase saga, details of which Samuel Okudzeto Ablakwa, now Foreign Affairs Minister, serialized quite greatly, resulting in a number of concerns being raised. One of such concerns picked up by the Office of the Special Prosecutor. Then there is a GRA tax petroleum fund management. Of that account, there's been concerns about disbursement, amongst many other things. The Office of the Special Prosecutor has taken it up as a subject matter of interest and is looking into it. But here's where it all started. The 2nd of January 2025, Mr. Ofori-Atta wrote to the former Chief of Staff, because remember, as at the 2nd of January, former President Nana Addo Dankwa Akufo-Addo was still president, awaiting the swearing in of John Dramani Mahama as President of the Republic. And so Mr. Ken Ofori-Atta wrote to then Chief of Staff, Madam Akosia Fremal Parry, to seek medical attention abroad. Now, on the 22nd of January, Ken Ofori-Atta wrote to the current Chief of Staff, Julius Zebra, informing him of his absence from the jurisdiction. Now, 2 days later, the Special Prosecutor or his office wrote to the former Finance Minister asking him to attend an interview on the 10th of February at the OSP as a suspect in respect of 4 corruption and corruption-related offenses. At that time, it was 4, but subsequently it got upgraded to 5. Then on the 31st of January, Mr. Ofori-Atta's lawyers wrote to the office as well that Mr. Ofori-Atta has taken or sought redress at the Human Rights Division of the Accra High Court, seeking to bar the Office of the Special Prosecutor from declaring him as a wanted person going forward, and as well taking steps to remove that initial wanted notice from any of its registered documentation. Let's go on to the phone lines right now and speak to Inusa Abdullahi Bista Fusheni. He's a private legal practitioner. I'll pick his thoughts on the latest we're getting to know of this standoff or this tango between the former Finance Minister and the Office of the Special Prosecutor. Counsel, I appreciate you speaking to us this afternoon. What do you make of this latest development, the unavailability of the former Finance Minister, and really what recourse is now available to the Office of the Special Prosecutor in this interview, which they describe as crucial in proceeding with their case?
Well, thank you for having me. I think that it is now becoming abundantly clear that Ken Ofori-Atta does not intend to make himself available to the Special Prosecutor to assist in the investigations of the matters that have come before the Special Prosecutor. And so the option appears to be what the Special Prosecutor earlier took, the steps that he earlier took, that is declaring him a fugitive from justice, a wanted person.
Well, you say he's not interested in making a return. His lawyers have a contrary view. In fact, they've served the Office of the Special Prosecutor with documentation from what we know, suggesting that his health situation has taken a turn for the worse. In fact, that suits they filed, where we are expecting a ruling on June 18, they've made copies of these documents also available to the Human Rights Division of the High Court. That's evidence of the fact that he cannot be available.
The fact is that the fact that the lawyers of Ken Ofori-Atta have presented or are alleged to have presented documents to the Special Prosecutor alleging that Ken Ofori-Atta's health conditions have deteriorated does not in any way overreach the powers of the Special Prosecutor to demand that he appears before him to enable him investigate matters that have come before him.
But really, what course of action can the OSP be taken? Because we know that there is that June 18 ruling expected by the Human Rights Division of the High Court. He can't possibly proceed to want to declare him wanted again, can he?
Nana Ofori-Atta is in court, in the Human Rights Court, to vindicate a right that he thinks he has, and he's doing that through his lawyers. Until the Human Rights Court pronounces or upholds the rights that he thinks he has, in not appearing before the Office of the Special Prosecutor, nothing prevents the Special Prosecutor from continuing with his job in terms of demanding that Ken Ofori-Atta appears before him. So the Special Prosecutor will proceed. I mean, you can use the court to frustrate the performance of a function given to the Special Prosecutor by a statute. And so the Special Prosecutor will prosecute. I will advise that he proceeds until the court rules otherwise.
Where do you stand, though, in the argument being made that the processes up until now, it does appear the former finance minister has had his way and that the OSP should proceed, nonetheless, whether or not Ken Ofori-Atta is present, and build a case against him and take it to court rather than this merry-go-round as to an appearance or not?
Yeah, this is a criminal matter. He's being wanted in connection with the investigation into some alleged crimes being committed, and make himself unavailable to the Special Prosecutor and still think that the Special Prosecutor can continue with the investigation. The investigations that are being carried out of the Special Prosecutor will require the presence of Ken Ofori-Atta to answer those questions. And so I do not see how the Special Prosecutor can proceed without the accused person appearing before him.
And where does that leave us if he continues to, on the basis of his health, does not appear? What really is the course of action that can be taken if he's
so
unwell?
that will go into matters of
subscribe, share, you might like. God bless you.